Today programme on BBC Radio 4. Here is a piece of European Court of Justice legislation. It was arrived at this year. Airlines are not liable to pay compensation when delays are caused by bird strikes. Simple. It's British law as well because we're in the EU. And when we leave, it will remain British law. But that judgment was an update of previous judgment. It changed. And this is the crux of the worry that senior judges here are expressing. In cases in the future, when the European Court of Justice changes existing legislation, what do our courts do? If the court changes its mind on something or changes the rules for an agency? The point that Lord Neuberger, the outgoing president of the Supreme Court, is making this morning is that these issues have to be addressed and resolved. Let's hear a bit of what he's been telling our correspondent Clive Coleman.
Parliament should be very clear in telling the judges what to do. Because if it doesn't express clearly what the judges should do about decisions of the European Court of Justice, then the judges will simply have to do their best. But to blame the judges for, as it were, making the law when parliaments fail to do so would be unfair.
That was Lord Neuberger. We will hear in a moment from Owen Paterson, the Conservative MP, former Environment Secretary, who campaigned to leave the EU. But first, let's talk to Dominic Grieve, also Conservative MP, former Attorney General, who supported the Remain campaign. Good morning, Mr. Grieve.
Good morning.
Does Lord Neuberger have a point?
He's absolutely right. The legislation for withdrawing us from the EU, which we're about to start in September, leaves very unclear what the relationship subsequently between European Court of Justice decisions and jurisprudence and our own courts should be. We're incorporating large amounts of European Union law into our own law so that we can ensure continuity. But how is that to be interpreted thereafter? Should our courts apply the same form of interpretation that is done by the European Court of Justice, or should it follow our own national practices? That could lead, in some circumstances, to different outcomes. If indeed the idea is that we're keeping European Union law, because in future we're going to want to mirror European Union law in many areas. If, for example, we have some sort of free trade agreement and we have to trade into a single market and observe its rules, then how are we going to ensure in those circumstances that our law is interpreted in the same way? Because ultimately we will be, I'm afraid, bound to follow what the European Court of Justice is likely to hold applies to the 27 other member states.
Hasn't the government left that open by saying the court should consider European law where it was appropriate? They have left it open for the courts to do exactly that, where they think it's the right thing to do.
Yes, they have. But on the other hand, I think the point that Lord Neuberger is making is that that leaves a very wide measure of discretion to our own judiciary. And what he's saying is there's no point in those circumstances turning around at some subsequent point and saying, well, the judges are interpreting this in a way that is causing us, for example, difficulties because we're no longer in conformity with our EU, with the EU with whom we are having to trade. There are real complexities relating to the whole of the withdrawal bill that we're about to look at. Quite apart from giving massive powers to the executive, there is a real state of uncertainty. For example, just to give another example, there are areas where currently a British citizen can invoke principles, basic principles of EU law to challenge a Commission directive. But we won't be bound by those basic principles of EU law necessarily in future. So interestingly enough, the individual's position may be jeopardized against such laws and be less strong than it would have been if we'd stayed in.
Just stripping away the complexity, though, couldn't you just say, look, hang on a second, the European Court of Justice will become the court of a foreign nation or group of nations, just as the American Supreme Court is the Supreme Court of the United States, and we have to follow their directions in as much as when we trade with the United States, we can't break US law, or it'll just be the same with Europe.
That's a perfectly valid point, but the thing is that our relationship with the EU, even when we've left it, is going to be infinitely more complex because of the level of trade and the level of exchange that takes place. So to do that within a framework of international relations where you have international law, and yes, we're bound by many international treaties, and some have tribunals to interpret them, it's going to be quite a top-heavy and ponderous process. The whole reason why the European Court of Justice was created with its direct effect was precisely to cut through that problem and to ensure that there was conformity across the EU members. Now, we don't wish to be in the EU. We want to be outside of it. And we're going to have to try to find some mechanism by which we can operate outside. But of course, the risk to us is to end up, as some countries like Norway have, which is effectively to be dictated to about what you do without being able to provide any input. This has always been a potential risk. Or alternatively, you have to cut yourself off from the European Union completely and have very few links, in which case our trade may suffer as a result.
Dominic Grieve, thank you. Let us turn to Owen Paterson, as I say, Conservative MP, former Environment Secretary, campaign to leave the EU, is on the line from Shrewsbury. Good morning to you.
Hello, Justin. Good morning.
When Dominic Grieve says the situation is different, you can't compare our relationship with the European Court of Justice with our relationship with, say, the American Supreme Court, simply because of the level of our involvement with Europe and our continuing involvement. He's right, isn't he?
Well, I agree with a lot of what Justin said, but I don't entirely agree with that last point. I mean, on the 30th of March 2019, because we have triggered Article 50, we will leave the European Union, and the treaties will cease to take effect. We will cease to be under the remit of the ECJ. And along with 50 other countries who have free trade agreements with the EU, we will have a new arrangement. And none of those other 50 countries have to submit to the jurisdiction of the ECJ, as the Commission has currently proposed, for instance, for EU citizens. Not even, very modest countries like Andorra or San Marino are subject to jurisdiction. They have an arbitration process. So I think your point is right. We are not subject to the rules of the Supreme Court of the United States on matters affecting US citizens in the UK. They are subject to our UK judicial system. And that will carry on. Where I think Lord Neuberger has a very good point is there has to be clarity. And what is quite clear in the withdrawal bill, it's absolutely clear that we will leave the remit and the jurisdiction of the ECJ on exit day. But it does say that interpretation could be considered. And I think there is a role to set up a UK judicial arrangement, some sort of tribunal, possibly similar to the Competition Appeal Tribunal, with specialist UK lawyers adjudicating on interpretation of the treaty arrangements which we will have with the EU. And that would balance out in quite a nice symmetrical manner the role of the ECJ, which perform a similar function, as it will continue to be the Supreme Court of the European Union.
So just to be clear, those would be British lawyers then?
British lawyers, yes.
Who would be advising the Supreme Court on when it was appropriate to consider European legislation. Yes, Dominic Grieve gave a few examples, didn't he, where British citizens are involved and where, in a sense, we are dictated to by the European Court of Justice. For instance, if we're following, I don't know, in the Medicines Agency or somewhere, the rules that they change, then that tribunal could say, yes, you should follow that change.
Yes, but of course, all those rules by then, because we'll have effectively nationalised the acquis, the whole corpus of EU law and taken into UK law, that will all be interpretation of UK law. But there will be this new treaty arrangement. It sounds
like an awful lot of layers of complication. Well, actually, we could just say, look, let's just follow what the European Court says when it refers to us. In other words, we've made a bogeyman of this court, which is going to damage us.
Well, I don't agree with you quite on Justin on that, because the ECJ has all along been an absolute key promoter of greater harmonisation and ever closer union. It refers frequently to the spirit of the treaties and interprets the treaties in its own way towards ever closer integration. And that is totally incompatible with our promise at the referendum to take back control and bring law back within control of our Parliament. But that does not mean to say we cannot create a new body staffed by skilled, knowledgeable UK lawyers who could give advice and interpretation of our new treaty to courts with less specialist knowledge. And I think that's what Lord Neuberger is looking for. And he's absolutely right. You cannot leave the judges flapping around without clear guidance. And I would suggest we set up our own body which would parallel and mirror and be in symmetry with the ECJ, which perform a similar role within the EU, which is effectively moving, and will move, I think, very rapidly now that we are no longer the pebble in the shoe, will move to a much more closely integrated political entity.
Where do you stand on the European arrest warrant? Because that, of course, is something that is both to do with the European Court of Justice at the moment and potentially not to do with it in the future. In other words, we could withdraw completely and the Supreme Court could have the final say on whether a British citizen should or should not be extradited to a European country. Where do you stand on that?
Well, I think that comes within our promise to take back control of our laws. That those issues must be decided by our own legal system and our own Supreme Court. So go back to, you mentioned the Supreme Court of the United States. It would be inconceivable, I think, the United States would accept powers imposed on US citizens, and I think we will have a similar standing.
But what if that damages then our relationship with the EU when it comes to criminal matters that are so important to us as well?
I don't see why it should. The EU has very good relations with neighbouring countries with whom it does not have an arrest warrant arrangement, and I think that can continue. But I think we will be letting down those who voted. And don't forget the 17.4 million, and we've had a huge vote in Parliament, 494 votes to trigger Article 50. We made a very, very clear promise to take back control of our laws into our own Parliament. And I think that cuts across the board. Now, that absolutely does not exclude the very closest cooperation with our European neighbours, but ultimately there must be a recognition that the ECJ does not have a remit to tell UK citizens what to do. And very importantly, it does not have the remit also to tell EU citizens or to give them a special status, rather like British citizens used to have in the treaty ports in Shanghai and Canton after the Treaty of Nanking and other treaties, which the Chinese were very, very unhappy about.
Final one on the money, not the precise figure, but there's been much in the news recently, tens of billions potentially that we are going to pay the European Union when we leave. Is that a problem for you if it is tens of billions?
I think there will be legal obligations, and we are a respectable state. I said in your programme not long ago that we've kept our obligations ever since Edward III. He was the last one to break them and crashed some Florentine banks. There will be then ongoing programmes, might be Horizon, might be Erasmus, where we will be probably enthusiastic participants. We were big players in CERN before the EU was founded. We are big players in CERN within the EU, with the second biggest contributor, I think. We will carry on afterwards. But
so if it reaches tens of billions of pounds, if it reaches up towards 40, that might be all right with you. If it's money that the European side in this can demonstrate is money that is usefully spent.
Well, hang on, those sound to me, frankly, balmy figures, considering we have been massive net contributors.
What sort of sum is not balmy, then?
I'm not going to put a figure on it, Justin.
Well, hang on, if they're balmy, there must be some that isn't balmy.
No, you're not being fair, because I don't know, nor do you, what the programmes that we're going to continue are. So Erasmus, Horizon, they're going to be very modest.
But not tens of billions, then?
I would be most surprised if it's that figure. And I think you have to remember the huge contribution we have made as the second biggest contributor for many years to the EU. There is a very good case they could give us some of our money back.